Good morning and good evening, everyone. Thank you for joining this webinar organized by the British Association of Comparative Law, BACL, as we call it. I am the chair of BACL. I have less than a minute allocated to me. I'd simply like to express our thanks to the Society of Legal Scholars and to Durham University for including us in the program of the SLS conference. Our chair today is Dr. Oliver Butler. Oliver completed his PhD on information law at Cambridge University, and Oliver is currently an associate research fellow at the Bonaventure Institute of Oxford, and he will shortly start a lectureship in law at the University of Nottingham. Oliver, many thanks for chairing this webinar, and over to you now.
Many thanks, Sophie, and good morning and good afternoon, depending on where you are and where you're joining us from. The purpose of this seminar is to look at the regulation of hate speech online and its enforcement in a comparative perspective. We have 7 brief presentations this morning, followed by a Q&A. So please do put things in the Q&A function during those, and I'll draw upon them at the end. We have Professor Uta Cole, who's a professor of commercial law at the University of Southampton, who's written extensively on internet governance issues, followed by Professor Matthias Hong, who's professor of public law at the Hochschule für Offentliche Verwaltung und Recht, who writes, amongst other things, on the German Network Enforcement Act. Then followed by Professor Thomas Hockman, who's professor of public law at Paris-Nanterre University and is a member of the Institut Université de France. That'll be followed by Dr. Peter Coe, who's a lecturer in law at the University of Reading, who's got a forthcoming monograph on media law freedom in the age of citizen journalism. After that, we'll have a presentation by Professor Jacob Rowbottom, who's professor of law at the University of Oxford, recently published Media Law in 2018 and has research interests across media law, freedom of expression, and the legal regulation of democratic process. That will be followed by Dr. Ge Chen, who's assistant professor in Chinese law at the University of Durham. He specializes in Chinese media law and information law, and is the author of Copyright and International Negotiations, an engine for free expression in China. Our final presentation will be Professor Andrew Kenyon and Dr. Anjali De Silva. Andrew is Professor of Law at the University of Melbourne, researches on comparative media law, having just published his book, Democracy of Expression. Anjali is a postdoctoral fellow at the University of Melbourne, who researches on free speech and media law and theory, including a focus on harmful speech and its regulation, especially online. This morning, we'll be looking at the various tools that shape narratives online and why those different tools are used in different jurisdictions. So given the tight time that we're under, I'll now pass on to Professor Cole, who will be speaking on hate speech, online hate speech, a transatlantic discourse on empowered citizenship. Thank you.
Thank you, Oliver. First of all, thank you to Oliver and Sophie for giving me the opportunity to present at this seminar. I'm going to talk about online hate speech and the different legal attitudes to hate speech on each side of the Atlantic. I will argue that they're historically grounded, enjoy in their social history grounding equal legitimacy, and are ultimately fundamentally irreconcilable, but find an awkward compromise in the German enforcement law and like regulatory initiatives. So starting with the historic grounding, I want to refer to James Whitman's wonderful article of 2004 entitled The Two Western Cultures of Privacy, Dignity versus Liberty. My argument is that his historic tracing of the fundamental differences in privacy conceptions in North America and continental Europe, one being based in liberty, the other being based in dignity, can be extended to free speech. So I'm saying the broad themes that underlie the privacy constructions on each side of the Atlantic are also applicable to the hate speech or to speech attitude attitudes on each side of the Atlantic. So he looks at continental European law on privacy and argues that it must be understood against the strict hierarchical societies in Europe. Privacy must be understood as being grounded in dignity as forms of leveling up, whereby dignity and honor, which were traditionally reserved to the upper classes, became a universal entitlement. So there was a democratization of dignity, which underlies European understanding of empowered citizenry and recognizes that public insight and humiliation are tools for disempowerment and exclusion and are inconsistent with legal and political equality. In this context, in continental Europe, the state is understood as the enabler of privacy and of equal entitlement to free speech by extension, by protecting private parties from humiliation suffered at the hands of other private parties. In that context, I also recently came across a very interesting book by German legal historian Ute Frevert. It's called The Politics of Humiliation and Modern History, where she outlines a gradual shift from humiliation to dignity, which occurred in Europe from around the early 19th century. And I quote her here, where she argues lower class people increasingly objected to disrespectful treatment and used the language of honor and concepts of personal and social self-worth previously monopolized by the nobility and upper middle classes to demand that they not be verbally and physically insulted by employers or overseers. The social change was enabled and supported by a new type of honor that followed the invention of citizens rather than subjects in democratizing societies. So she, in her book, much in line with Whitman's article, argues that humiliation works as a tool of exclusion that denies self-determination at a very basic level. So dignity basically gives that inclusion and gives an entitlement in equal participation in society. Now, this construction of empowered citizens as a form of leveling up of dignity enabled by the state is profoundly at odds with the American view of empowered citizenry and by implication of privacy and free speech. The American conception of privacy, but also speech, is based on liberty, which is deeply inscribed with settler mentality. And settler mentality is one of self-reliance and self-rule and distrust of government, whether the old world governments left behind or the colonial administrations belatedly encountered in the New World. In the Wild West, the universal immigration status acted as a powerful equalizer that made the imperative of leveling up of dignity redundant. By the same token, the state was perceived not as an enabler, but as a primary threat to empowered citizenship, which in turn found legal expression in the First Amendment, as well as in the American conception of privacy. Fundamentally, it's not for the state to intervene in private relationships to protect dignity harms. In fact, dignity harms are not recognized as legal harms. So it's in America, it's not so much about whether hate speech is a good thing or bad thing, but whether it is up to the state to interfere in the speech environment. And fundamentally, there's a distrust against the state that the state cannot be trusted to do so neutrally and objectively in the interest of all. So neither the continental European nor the North American conception of privacy, speech, equality is more or less legitimate. They're historically grounded and today are constitutive of the respective government-citizen relationship. Different approaches to hate speech simply represent the respective values embedded in that historically grounded relationship. Now, coming to the internet. The internet has really basically given rise to a global speech landscape and thereby interfered with what you might call territorial silos within which the different conceptions of speech and regulation generally could be enacted. The globalization means that these different conceptions of what is good and bad in good and bad regulation have come to clash. Now, on the internet, one of the things which has happened is the territorial compartmentalization or balkanization, whereby states basically, and particularly in Europe, have insisted that global online platforms and global actors generally, online actors generally, have to comply with their norms. And this is really what lies behind the balkanization. Of course, that's not an ideal development. And ideally, of course, we would want to see some convergence of the regulatory landscape to counteract this type of balkanization. Now, the question is, are the different attitudes to speech, to hate speech, reconcilable? Is there a middle ground between the North American view and the continental European view? The starting point here is that they're not reconcilable. They're neither reconcilable nor resolvable. Whilst dignity and liberty are values embedded in each system, they're given very different meanings in each system. And there is fundamentally a very different understanding of the role of the state as an enabler or as a threat to their realization. Now, my argument here is, and I can only make this very, very briefly, is that the German network enforcement law and similar initiatives, which are underway in France and in Britain, creates an awkward halfway house between the two systems. On one level, you might say that the German network enforcement law, and I don't know to what extent you all know about it, basically it requires platforms to act as, to respond to takedown notices on illegal speech, and thereby make judgments about what is and is not hate speech and other illegal speech. On some level, you might say that it continues both on a substantive and a jurisdictional level, previous normativity in relation to dignity, continental European understanding of dignity, and how the state needs to act to basically protect our dignity in private relations. Now, on another level, however, you may also see that it's not simply a continuation of what has happened before, but that it in fact presents a compromise with American legal sensitivities, insofar as it establishes a public framework for private censorship. And the latter is not alien to the American worldview. Now, how is this a private censorship enacted? First of all the blocking or takedown initiatives are started through private notices. So if you see anything in the German law space online that is you consider hate speech, you can give notice to Facebook and other platforms about that. It is then implemented through corporate processes, which are only imposed on the very largest platforms that have the capacity to do so. Because although the law is called the network enforcement law, we are not talking about some form of mechanical enforcement, but actually these large corporate platforms are expected to engage in adjudication with a lot of discretion. So they in fact implement and decide what is and is not illegal content. Now, whilst there may or may not be an appeal after this decision, broadly speaking, these platforms make the vast majority of decisions and interpretation of what is hate speech and what is not. In terms of compliance, even here you might say that platforms are very much left to their own devices, because it is, they are not judged on individual failures of how they exercise their discretion, but really the penalties attached to a failure to have processes in place to exercise the discretion. So it is not the individual decision that exposes them to non-compliance and penalties, but rather the lack of a process, the lack of, they get penalties for not having processes in place to make those decisions. Now, lastly, and I'm running out of time, is this a successful compromise between the North American and continental European system? On one level, you might say, yes, there's a public framing, a public framework for private censorship. Private censorship is entirely legitimate within the US. Public censorship is, or public framework is compatible with the European, continental European system. There is in fact also no evidence that platforms have removed more contents after the adoption of the law than before. So you might say that the law is merely framing what the platforms would have done in any event. Having said that, I think it is a very awkward compromise that leaves, in fact, both camps dissatisfied. From both perspectives, there's an undue interference with free speech, but for entirely different reasons. From an American perspective, there's an undue governmental censorship of content, and the private actors act as agents of the state. From a continental European perspective, there's insufficient public oversight over undue private censorship and insufficient accountability. So whilst it is no doubt a compromise, it is certainly in a very awkward compromise between the two systems that are, as I said before, profoundly at odds with each other. Thank you.
Many thanks for that fantastic presentation. If I hand on next to Professor Hong, who will be talking on regulating hate speech online while protecting freedom of speech as an equal right, comparing the US, Europe, and Germany.
Thank you very much. How does freedom of speech as an equal right shape the regulation of hate speech and disinformation online? How can we counter such harmful speech, secure equal dignity, the right to respect for personality, and save democracy from populist and autocratic attacks without giving up the freedom of thought and speech for dissident and even hateful ideas as such, regardless of their viewpoint or content, which is so indispensable for democracy itself? In my contribution for the publication resulting from this webinar, I will compare the answers that the United States of America, Europe, and Germany give to these questions and the different tools that are used or not used to address this regulatory challenge. In my remarks today, I will focus on 3 points. First, the prohibition of viewpoint discrimination should be recognized as a baseline of free speech across jurisdictions. Viewpoints or ideas as such do not justify restricting speech. Second, freedom of speech should be understood as an equal right and as a positive freedom, and as such should be accorded horizontal effect against private parties. The German Network Enforcement Act, NetzDG, is an example. Although it is commendable as an attempt to protect countervailing values, in its current form, it violates freedom of speech in its horizontal dimension, since it incentivizes overblocking of legal content. Third, the interpretation of free speech rights and government competences should also take into account the manifest dangers of disinformation. The horizontal effect of freedom of speech should oblige private social media companies to provide for some fairness and diversity of viewpoints on their networks. And neither private actors nor the government should have an unlimited right to lie and spread disinformation. The first point concerns a central element of the worthy tradition of free speech under the First Amendment. Viewpoints or ideas as such cannot justify infringing freedom of speech. This principle of freedom of thought should be respected as a common element of freedom of speech across jurisdictions. only a significant risk of harm for a legally recognized individual or collective interest can justify restricting hate speech, but not the interest in suppressing certain ideas as such. This is one regard in which Europe can, in my view, learn from the US model. The case law of the European Court of Human Rights in Strasbourg needs adjustment in this regard, since it is still lacking any meaningful prohibition of viewpoint discrimination, which is crucial under the First Amendment as well as under the German Constitution. In most other regards, the European free speech rights rightfully provide much less protection against state action, but much more protection against private actors than the First Amendment does. The rights to free speech under the ECHR, the EU Charter of Fundamental Rights, and the German Constitution allow more state regulation and restriction of hate speech online than the current US law. And they contain important positive obligations, especially through their horizontal effect, which obliges private parties to respect free speech and balance it against countervailing interests, especially against the fundamental rights of victims of hate speech. As Andrew Kenyon has convincingly shown, the European rights guarantees thereby protect freedom of speech as a positive freedom of plural public speech in a democracy of expression. In its recent judgment on public broadcasting fees of August 5th, the German Constitutional Court has forcefully renewed its commitment to such positive constitutional obligations. In this regard, the current US Supreme Court should therefore listen to those US scholars who have long since argued for a balancing approach to free speech and for an understanding of free speech as a positive right. The state, to refer to Uta Kohl's presentation, is not only a threat to, but also an enabler of free speech. But viewpoints or ideas as such do not justify restricting hate speech. Harms justifying such restrictions might be public peace, if narrowly understood, as peacefulness or absence of violence, or the right to personality, if it is also understood properly narrowly, as the right of persons for which such harm can be individualized, but not of groups of an innumerable size, like all women, for example, or all soldiers, or all policemen worldwide. Another important interest, harm for which might justify restrictions, is the protection of freedom of speech itself, understood as a positive right, against the manifest dangers of silencing of speakers, especially of members of historically disadvantaged groups, to which Andrew Kenyon and Anjali de Silva point. It might vary between cultures which interests are legally recognized, of course. The right to personality or honor or dignity is a main example for this, since the US does recognize hardly any such right at all, at least as far as harms inflicted to it by speech are concerned. Uta Kohl pointed to this difference. It might also vary between cultures which threshold has to be reached to justify a restriction of speech, which magnitude of risk will suffice. What should be recognized across jurisdictions, however, is the principle that the protection of some legally recognized interest from harm, not the viewpoint or idea as such, has to be the justification for restriction of speech. My second point, freedom of speech should also be accorded horizontal effect against private parties. In Germany, the horizontal effect of free speech has led the Constitutional Court, for example, to order Facebook to unblock the account of a right-wing party for its campaign ads before an election. The German Network Enforcement Act, NetzDG, tries to fulfill such constitutional obligations. As such, it is a commendable, if apparently insufficient, first step to regulate online hate speech. However, in its current form, it violates the right to free speech in its horizontal dimension, since it does not contain enough protections against an overblocking of legal content. The Act obliges the big social media companies to establish an effective and transparent procedure for handling complaints about unlawful content, ensuring, for example, that manifestly unlawful content will be removed or blocked within 24 hours of receiving the complaint. Systemic failure to keep such a procedure available can lead to fines of up to 50 million euros for companies. This is as such justified, but there are not enough protections against overblocking. The new procedure for counter-complaints, paragraph 3b, in force since 28th of June, is not sufficient to correct this defect, since there is still no duty to put back even manifestly lawful content and no counterpart for the strict 24-hour time limit for removing or blocking. This one-sided regulatory approach is problematic, regardless of how much overblocking the act exactly causes. Although it does not seem to have been a massive amount, a study of 2021 indicates that it has caused at least some overblocking. And the question is not so much an empirical one about big numbers, but first and foremost a normative one. Even if only a few persons cannot speak, although they have a constitutional right to do so, severe constitutional damage is done. To be clear, there has to be some latitude for house rules of a private social media company to establish and define its character. For example, as one suitable for minors only. So there can be no universal right to publish every legal content on every network. But if content has been erroneously removed or blocked as illegal because of Netzdg, there has to be an equally effective remedy to put it back in. My third and last point. The interpretation of free speech rights should also take into account the manifest dangers of disinformation. Government speech should be subject to at least certain obligations of neutrality and objectiveness. And neither government nor private parties should have an unlimited right to lie and spread disinformation. And the doctrine of horizontal effect of fundamental rights should lead to some fairness obligations for private social media networks. In Germany, such constitutional obligations have long since been established for state actors, who have to provide for a diversity of viewpoints, for example, when allocating access to public spaces like town halls. They have also been established for public broadcasting companies. The Strasbourg Court's case law is similar in that regard. By the same reasoning, some measure of fairness has to be constitutionally obligatory for private social media companies as well. To sum up, my comparison of the US and Europe will have three results. When regulating hate speech online, first, do not suppress ideas or viewpoints as such. Second, protect speech and other fundamental rights horizontally as positive freedoms. And third, restrict private and government disinformation. Thank you very much for your attention.
Many thanks for that really interesting presentation. If we hand on next then to Professor Hockman, whose presentation is entitled Hate Speech Online, the Government as Regulator and a Speaker.
Thank you so much. Hello, everybody. Many thanks to the organizers of this seminar. I'm really happy to be here, even though I do not like those Zoom meetings. I think it's really difficult to have a real academic exchanges on Zoom. So I can say that I hate speech online. You got it. You see, if we were together, I would have a polite laugh for this joke. Now I have only silence. It's quite difficult to bear. But okay, so in the short time allotted to me, I would like to make 2 points which relate to the government as regulator of social networks, but also to the government as speaker on social networks. The two are not unrelated. When Twitter began to react to Donald Trump's excesses in May 2020, the President of the United States announced a reform to drive social media into a position of total non-interventionism. Conversely, when Twitter permanently suspended Donald Trump's account, the French government used this decision as an argument to demonstrate the need for better supervision of social networks and in particular to lead them to greater intervention against disinformation and hate speech. So as a regulator, first, the government works to encourage networks to suppress punishable language while protecting freedom of expression, as the first two speakers recalled. This regulation of social networks can take several forms. It seems to me that there are two distinctions that can be made. The first is between obligations of results and obligations of means. The government can order social networks to effectively remove illegal contents and only them, or it can force them to implement a regulatory system capable of achieving this goal. Then we can distinguish, it's close, but it's not exactly the same. I think we can distinguish between a concrete or systemic approach. The two first speakers also mentioned this. In the first case, in a concrete system, each concrete failure to meet the obligations is punishable. In the second case, with the systemic approach, it's only a generally unsatisfactory behavior of the social networks that can be sanctioned. In France, a first intervention by the parliament, the so-called Aviar Law, last year in 2020, this law was deemed unconstitutional. It provided for obligations of means, but it also established obligations of result as part of a concrete system. This means that every single failure to remove certain contents within 24 hours was punishable. Conversely, the problem of overblocking was only treated in a systemic way. The result of this system was an inducement to suppress in doubt for the social network. And such a system did not sufficiently take into account freedom of expression. For this reason, the law was unconstitutional. This last summer, so 2021, the French Parliament passed a new law that addresses multiple topics, including hate speech online. As regards more precisely the regulation of social networks, the law only sets up obligation of means this time and not obligation of results. And these obligations are sanctions in the event of a systemic failure only and not for each particular case. This mechanism entered into force without being controlled by the Constitutional Council. Now, social networks have a number of obligations imposed on them. They must be transparent about the means they implement to remove illegal content, but they must also show how they oversee decisions to delete accounts. And these means must be sufficient. If it's not the case, an administrative authority, the so-called CSA, can impose real heavy penalties. So it seems to me that these new measures seem less inspired by German legislation, which was not mentioned during the parliamentary work. These new provisions are intended to anticipate the Digital Service Act, which is in preparation at the European Union. And the French law is supposed to be replaced by the European regulation as soon as it will be adopted. Okay, so maybe the European regulation itself is inspired by the German legislation. So in this case, in this way, the NetzDG had an influence in France. So the details of the new French law are not my topic here. I don't want to go too far into the details, but this law takes freedom of expression more seriously than the previous law, the Aviar Law, did. The law takes into account the place occupied today by social networks that have been described as the new public forums. The law tries to impose on them respect for freedom of expression. So that's what we can call, with Matthias Hong, an indirect horizontal effect. The state, through a law, imposed to a private actor the respect of fundamental rights. As the Minister of Digital Transition, we have such thing in France. The minister said during the parliamentary work on this law, it's really difficult to quit the large social networks. This is also why there are not several Facebook, Twitter, or TikToks. Consequently, one can consider that the large networks, which are private companies, nevertheless have certain obligations under the supervision of public authorities. Another way of expressing the same idea is the phrase of Spider-Man's uncle, quoted in this context by the European Commissioner for Competition, as well as by the Parliament member Laetitia Aviar. As you know, with great power comes great responsibility. This tension between the desire to suppress dangerous speech and the desire to preserve freedom of expression is particularly virulent when the government is the speaker. On the one hand, we can defend the idea that the government speech is more harmful than private speech. Being stigmatized and insulted as a homosexual, for example, does not have the same impact when the speech comes from the government itself. On the other hand, it's obvious that the expression of government officials contributes to debates of general interest. The public has a strong interest in knowing what the government is saying, even if what the government is saying is hate speech. And more generally, the fact that a private power can partially silence the government poses an obvious democratic problem. So when attempting to regulate social networks, the government shall not forget that it is also a user of those networks. The law on the dissemination of fake news, adopted by the French Parliament in 2018, can serve as an example. The only legal complaints to date for the dissemination of fake news has affected the expression of a member of the French government. The complaint did not succeed in court, but it shows that the government should remember that, as a user of social networks, the instruments it develops to regulate them and to force them to regulate more speech, those instruments can always backlash. I thank you very much for your attention.
Many thanks for that great presentation. I'm going to hand on next to Dr. Peter Coe, whose presentation is entitled "The Public Sphere, the Online Safety Bill, and the Regulation of Online Harms and Hate Speech. Have we opened a Pandora's box?" Thank you.
Hi, everybody. Hopefully you can all see my screen that I've just shared, and you can see the PowerPoint slides that I've put up. Yep, excellent, thank you. So you'll see that in the title of my paper, I asked whether the draft online safety bill and how it intends to regulate online harms and hate speech has opened Pandora's box of free speech. What I didn't realize when I started to write something on the bill is that I was actually going to be opening Pandora's box for myself. Now, I want to make it clear before I start that in my full paper, because of its similarities with the bill, I draw on Germany's 2017 Network Enforcement Act to provide an example of how the bill, once enacted, may impact on free speech in the UK. But because of time, I'm not intending to go into detail about that for the purpose of today's presentation. That's something that I'll talk about in future meetings, and also that I discuss in more detail in the full paper. So what's the purpose then of my research? What am I intending to do? Well, despite the uncertainty over what the Act will look like once it's enacted, I am asking in my research whether, as the bill currently stands, in passing a law to protect the public sphere from hate speech and other illegal and also legal yet harmful speech, we may unintentionally open Pandora's box by giving social media platforms the opportunity or even a statutory footing to take even more control of the message. By asking this question in respect of the bill and by using it as an example, my hope is that this work will provide guidance or perhaps even forewarning for the UK's legislators and also legislators in other jurisdictions who are looking to develop similar regimes. Now, one of the first things that I consider in my full paper are the reasons behind the online harm zeitgeist that's currently sweeping Europe and the rest of the world. So in other words, I ask the question, why do we need an Online Safety Act? And in discussing this, I use the UK's current fragmented two-tier liability system as an example, which I'll touch on now. Essentially, and I am simplifying this enormously because of the time I have, Tier 1 consists of online publishers, so anybody or any organization who publishes content online. Liability arises at the point of publication of the content. Is, for example, criminal, which of course would include forms of hate speech. Now, the current criminal regime for dealing with online speech adds further complexity to the system, as it may involve the commission of a number of offences under, and I use these as an example, Section 1.1 of the Malicious Communications Act 1988, and or Section 127, subsection 1 of the Communications Act 2003, both of which I will come back to in a moment for reasons that will become clear. The liability of online intermediaries falls under Tier 2. The scope of this liability is limited because the regime is subject to the safe harbour protections for intermediaries provided by Articles 12 to 15 of the European Union's e-commerce directive, which of course is applicable across the EU, but has also been retained in UK law by the European Union Withdrawal Act 2018. And these legal tools, just to add another layer, these legal tools have been supplemented by social media platforms committing in various different ways to self-regulate their activities and to combat harmful speech and hate speech on their platforms without the need for mandatory regulatory oversight. So the next question I asked then is, does the current liability system work? Well, in short, my answer is no, it doesn't. It's all a bit of a mess, certainly in the UK. And again, in the full paper, I go into detail as to why it doesn't work. And I provide some real world examples that illustrate the problems that come from it. But for the purpose of today, I'm going to summarize some of the points that I make in the paper. So firstly, liability systems that target publishers of harmful or illegal content, such as the Tier 1 regime in the UK, that were not designed to deal with online speech, are perhaps understandably unable to cope with the practicalities of the online environment. In the United Kingdom, the Law Commission has actually recommended recently that Section 1.1 of the 1998 Act and Section 127.1 of the 2003 Act that I talked about a moment ago are repealed and are replaced with a consolidated harm-based model. This is because our methods and our frequency of communication, the content that we're now able to publish, and therefore the number of publishers disseminating harmful and illegal content have fundamentally changed in recent years because of the internet and social media. Yet the suite of criminal offences has changed very little to adapt to the way that we now communicate. And this has led to two paradoxical phenomena. So on the one hand, these laws undercriminalise, in that despite causing substantial harm, many culpable and damaging communications simply fall through the cracks. There's no appropriate criminal sanction for them. On the other hand, by proscribing content on the basis of universal standards, such as indecent or grossly offensive content, the law as it stands criminalizes without regard to the potential harm, for harm in any given context. thereby over-criminalising. So notwithstanding how this may interfere with free speech, it also has the potential to swamp the criminal justice system. So even if for a moment you were to set aside the number of publishers that could be prosecuted for publishing illegal or harmful content, which in itself would require enormous police and prosecution resources, the transience of online publishers, the fact that they operate across different jurisdictions, and because they very often publish anonymously, and this is something I talk about in my full paper, means that even locating and identifying them is extremely challenging and resource intensive. Secondly, in respect of the e-commerce directive, there is a theoretical argument as to why the underlying rationale of its safe harbour protections is arguably obsolete. Recital 42 explains the limitations it places on the liability of online intermediaries exist because of their passivity, the fact that they are passive in the way they operate, in the curation rather, and dissemination and their hosting or indexation of content. Now, although this rationale certainly fits with the public message that's often conveyed by social media platforms, that they are just tech companies, they're passive tech companies, their actual activities say something very different, as it seems as though they are increasingly performing these editorial-like functions in the way that they curate and disseminate information. And also from a practical perspective, the directive's protections don't reflect the modern online environment and also social media as an industry. It doesn't take into account why content is managed as it is. So, for instance, to serve the platform's ideological agenda. It doesn't take into account internet business models, so for example, the use of clickbait to attract more users. And of course, how platforms have diversified from being simple hosting sites to multinational and multimedia conglomerates. So the last question that I deal with really in the paper is whether the online safety bill is the answer to these problems. Well, the bill represents the UK government's solution to the online harms problem, and a way of remedying the defects of the current system of liability. Now, whether or not this new regime is the answer to our problems is unfortunately impossible to say at the moment. Only time will really tell. But as I explain in my paper, duties of care that it imposes on platforms that fall within its remit raise a number of significant free speech concerns. And again, I'm going to summarize a couple of these concerns here, and there are many more that I touch on in the full paper. So essentially, and again, I'm just going to set out briefly what the bill says about these duties of care. So the bill sets out layers of duties that include, firstly, general duties of care applying to user-to-user services and search services. Secondly, additional duties for user-to-user services relating to children, and then further additional duties for what are called Category 1 services, which are currently undefined user-to-user services that are going to be included in a register which will be maintained by Ofcom. Now, these duties consist of what I call harder safety duties, which oblige services to protect users from illegal content, which will include hate speech, and protecting children and adults from legal yet harmful content. In respect of adults, this only applies to the Category 1 services. And this, I think, creates a number of problems. And as I've said, I'm going to touch on two of them here. So firstly, when referring to illegal content, by saying that it is content that amounts to a relevant offence, the bill essentially delegates the definition of those offences to other legislation. Now, unfortunately for hate crimes, that definition is rather murky and can lead to confusion amongst the public, platforms, Ofcom, and even the prosecuting agencies. So, which in turn can have serious implications for the operation of free speech. Now, we know the European Court of Human Rights said in the famous case of Handyside in the United Kingdom that the right to freedom of expression is applicable not only to information and ideas that are favourably received or are regarded as inoffensive, but also to those that offend, shock, or disturb the state or any sector of the population. Yet without a clear definition of hate speech, it is potentially very easy for these established free speech principles to be restricted. And this isn't helped by regular changes being made to definitions of hate speech and the different legal parameters of hate crime that exist across the raft of criminal laws that currently exist in the UK. My second point is that clauses 12 and 23 of the bill set out a general duty applicable to user and search services respectively to have regard to the importance of protecting users' right to freedom of expression and protecting users from unwarranted infringements of privacy. In addition, Clause 13 provides duties to protect content of democratic importance, and Clause 14 prescribes duties to protect journalistic content. However, unlike the clauses 12 and 23 duty, the clauses 13 and 14 duties only apply to Category 1 services. The fact that the core free speech duties pursuant to clauses 12, 13 and 14 of the bill only require platforms to have regard to, or in the cases of clauses 13 and 14, take into account free speech rights or the protection of democratic or journalistic content, means that platforms may simply pay lip service to these softer duties when a conflict arises with the legislation's numerous and harder-edged safety duties. Furthermore, and more cynically, this distinction between the harder and softer duties gives intermediaries a statutory footing to produce boilerplate policies that say that they've had regard to free speech or privacy or taken into account the protection of democratic or journalistic content. So long as they can point to a small number of decisions where moderators have had regard to or taken these duties into account, it's likely they're going to be able to demonstrate compliance with the duties to Ofcom, and it's going to be very difficult to go behind that process and interrogate it. So, in conclusion, I am running out of time here, by making online intermediaries responsible for the content on their platforms, the bill requires them to act as our online social conscience, thereby making them de facto gatekeepers to the online world. Although privatized censorship has taken place on platforms such as Facebook and Twitter since their creation, the bill gives platforms a statutory basis for subjectively evaluating and censoring content. This, along with the potential conflict between the harder and softer duties, could lead to platforms adopting an overcautious approach to monitoring content by removing anything that may be illegal, including content they think could be hate speech or may be harmful, and would therefore bring them within the scope of the duty and its regulatory sanctions. This risk is amplified by the lack of clear definitions of what is hate speech and also what is legal yet harmful content. And such an approach could lead to legitimate content being removed because it's incorrectly thought to be illegal or harmful. And cynically, and this is me being cynical here, it may provide platforms with an opportunity or even an excuse to remove content that does not conform with their ideological values on the basis that it could be illegal or harmful. Thank you very much. I'll hand back to Oliver now.
Many thanks for that really interesting presentation. Next, we're going to hand on to Professor Jacob Rowbottom, whose presentation is entitled Hate Speech, Soft Controls and Grey Areas.
Okay, thanks, Oliver. Right, so debates about hate speech often revolve around the question of whether the speech should be banned or whether it's entitled to full protection under the free speech principle. And when we hear those debates, questions often, is the speech worthy of protection? Is it political speech? Or are the harms that it causes to the democratic system so great that it should be taken out of the ordinary protection of political rights? Now, these are important debates, but I often think it gives this kind of sense of a misleading impression of an all or nothing approach. Either something is protected or it's kind of falls outside of the free speech principle and then it can be banned. And you can see this kind of traces of this all or nothing approach in some of the debates about social media regulation in the UK. There've been, as we've just been hearing, there've been proposals in the UK for certain forms of social media regulation, and a number of commentators have criticised those proposals on the basis that it would target content that is harmful but legal. And I guess the thinking behind that criticism is this view that if it's prohibited, then it can be a subject of regulation. But if, on the other hand, it's not prohibited under the criminal law, then any interference or regulation with that speech is inhibiting freedom of expression. So that's an example where we see an element of the all or nothing approach. I think this all or nothing approach often has its roots in the fact that the debates about hate speech laws have been formulated in the context or with a focus on criminal law measures. And those are criminal law measures which will, prohibit certain types of speech. They're basically saying it's never acceptable to say certain things. So the question when you're looking at a criminal law prohibition is inevitably something where it's all or nothing. Also, criminalization of speech, saying it can never be said, is a drastic measure. So normally there will be a high threshold before such a measure is permissible. So the main point that I want to make today is that there is no simple bright line that can be drawn between speech that is fully protected within the free speech principle and that which can be restricted. I think there are many different types of hate speech that are not prohibited, but on the other hand, we don't regard them as fully included within the political system or don't regard it as fully legitimate. So I regard this as kind of a grey area where you've got speech that's not prohibited, but on the other hand, it's not fully accepted. And when we're within the grey area, there are different degrees of hate speech, and they may warrant different types of legal response. So within this grey area, there may be softer controls on hate speech that are permissible, which stop short of an outright prohibition. And today I'm going to give you two examples of this. The first example is the denial of a benefit. So not a prohibition of hate speech, but denying certain types of hate speech certain benefits. And an example of this, let's say, for example, in a system, you've got a political party that is not banned, it fields candidates in an election, but it openly advocates racist policies. Okay, let's take that as an example. And in this system, the government gives state funds to political parties. They give the political parties free access to the public service media, and the leaders of those political parties are invited to participate in televised debates. Now, in such a system, one question is, could the state then deny those benefits to the extreme political party, even though the political party is not prohibited? So that might be an alternative response, simply to say, we're not going to ban the political party, but we're going to deny it state funding that we would normally grant to any other party. Now, if there is a denial of a benefit, I don't think you can sidestep the free speech question by claiming that there's no interference, by saying, well, it's not really censorship, it's just denial of a benefit. I still think it does engage free speech principles. The reason for that is that it's still government making a kind of assessment about what viewpoints are entitled to get a fair hearing. So you might have those arguments similar to those made by Professor Hong, that they are viewpoint-based restrictions. It's government making an assessment of the content of the message. Also, if we take the view that free speech entails certain positive obligations on the state to provide the resources that are necessary for the effective exercise of expression rights, then I think this question is going to become more pressing. Because if we take a positive obligations approach to free speech, then the denial of a benefit is more likely to engage the free speech right. So I think if we move to an approach where we accept there are certain positive obligations on the state to support speech rights, that raises something of a dilemma. Are we saying that the state should be under an obligation, a positive obligation, to provide support and resources to people who wish to disseminate hate speech that are not prohibited under the law? If that is the case, that feels fairly problematic to me, if we're saying the state has to support certain hate speakers. But on the other hand, the denial of a benefit departs from this ideal that we have that government treats different views even-handedly, or at least they do when we're in the context of political speech and public discourse and opinion formation. So I think if we accept the denial of a benefit, we are accepting something of a trade-off, where we are allowing government to take action based on its assessment of content or viewpoint, even though it stops short of an outright prohibition. So that's the first example that I wanted to give, was that of a denial of a benefit. That might be a measure that stops short of a prohibition. A second measure that can be taken by government that stops short of a prohibition is that of counter speech. Now, when we're dealing with counter speech, government doesn't prohibit the hate speech, but uses its own resources to provide its own messages, or to sponsor other speakers to counter the hate speech, to convince people not to adopt those hateful views. Now, proponents of counter speech and defenders of this approach see it as avoiding any free speech problems. What they would say is it doesn't amount to censorship. The government isn't stopping anyone from speaking. All the government is doing is providing speech of their own or sponsoring other speakers. But again, like the denial of a benefit, I don't think it's that straightforward. It's still the government using its powers to disadvantage certain viewpoints. So it's still making an assessment that it can use its resources to disadvantage or counter certain viewpoints. So you get that assessment of the viewpoint, assessment of the content. And where there is political speech involved, you might say the use of government resources in this way could raise certain issues of democratic legitimacy, because we certainly wouldn't accept that government can use their resources to counter speech just because they're opposed to it. You wouldn't allow government to use its communicative powers simply to counter the speech of a political opponent, those people whose views that they don't like. So what I think this shows is, if we accept hate speech as something that can be subject to government counter speech, we are accepting hate speech as a special case. We put aside our usual objections to government propaganda and government use of resources in this way, and we say, well, it's permissible in this case. So it's this idea that if we accept government counter speech, I think we are accepting that the normal rules about government communications don't apply when we're in the context of hate speech. So those are the two main examples that I wanted to go through. I think these softer controls, these measures that stop short of an outright prohibition, are going to become more important as we look at hate speech online. So, you know, it's things like measures that are being that people have in mind are the ones that Peter was just talking about. So it might be obligations to maybe not prohibit hate speech, but make it less visible. You know, so that might be one way to counter it. So that stops short of an outright prohibition. Also, government counter speech and government sponsored counter speech may become more important as well as a strategy of dealing with hate speech online. So I think these problems or these questions are only going to get bigger. So where does this leave us? Really, what I started off saying was that hate speech laws, when we're looking at criminal law, they're often opposed because of the reasons used by government to justify the action. And that again goes back to Professor Hong's point about viewpoint neutrality, about not interfering because government disagrees with the particular viewpoint or based on its assessment of that viewpoint. And I think that objection could in theory apply to many of the softer controls that I've referred to, such as denial of a benefit and government counter speech. But at the same time, it feels like this is a line that we might be willing to cross when we're dealing with measures that stop short of an outright prohibition. Maybe we are more willing to accept that trade-off where government takes a content or viewpoint-based decision in order to protect the democratic values. Now, when I was preparing this presentation, when I was thinking about these issues, I was struggling a little bit because I wasn't sure whether what I'm saying is utterly uncontroversial and would be accepted by everyone, or whether I'm being too flippant and willing to discard a central principle of the free speech jurisprudence. This may well come back to something that Jutta said at the start about the very different free speech cultures. So I guess it depends on where your starting point is. So I'd be interested to hear also how other jurisdictions deal with these types of questions, certainly as other jurisdictions provide, say, state funding to political parties and access to the media. I'd be interested to see if they have any rules to deal with hate speech there. But so like I say, I want to give these points more thought, but the basic point that I want to make is to suggest this simple approach where speech is either banned or it's fully protected. I don't think that's sustainable. I think governments are or were more willing to accept trade-offs between free speech and other democratic values once we start to look at measures that stop short of an outright prohibition. Thank you.
Many thanks for that, Russ. Really interesting presentation, really thought-provoking. If we hand on next to Dr. Gerchen, whose presentation is entitled Conjuring Up Equality Rights, How China's Statist Approach Fosters an Emerging Global Regulatory Patchwork of Online Hate Speech. Thank you.
Thank you, Oliver. So this paper is actually also a working paper, and I try to argue that this our world has seen also a kind of a division between the European and American model, as Jutta pointed out, and I also argue that this kind of a heterogeneous contours of free speech law or regulating online hate speech has continued and has shaped the current global framework. And my research shows how China's statist approach fosters in this emerging global regulatory patchwork. So we know that basically the classical, the conventional approach coalesces around the conflict between hate speech and equality. And if we take a look at primarily these two basic continental and common law systems, we see what Jutta pointed out is a discord between them. So in the European Court of Human Rights, the debate basically coalesces around Articles 10 and 14 and 17. So whether or not there is a conflicting value regarding Article 10, free speech and equality rights, in 14, and whether there is a misuse of Article 10 as enshrined in Article 17. So from several cases, we know that the European Court basically has ensured a kind of balancing act, right? So from Glimmer-Veen, we see how the kind of misuse was established as illegal under European law. And in Jersey, we see that the European Court pointed out that the press basically has a role to play as a public watchdog. And in the most recent case, Lily and Dar, we also see what Matthias Holm pointed out is the viewpoint of neutrality. But basically, the European Court relies heavily on the assessment of the viewpoint or contents. But on the other hand, the US Supreme Court or the US courts embraces the absolutist approach under the First Amendment, and in a series of hate speech or hateful speech cases, ranging from those landmark ones, such as Bohanner's. So we see that the US court, for the first time in the 1950s, did confirm the conviction of someone who raised a racist viewpoint. But then the US court seemed to deviate from that kind of line of arguments. And in Brev and Virginia, we saw that the US court has established a kind of viewpoint neutral jurisprudence. Most recently, in Meta case, we see that the US Supreme Court again reiterated that this was not possible this kind of viewpoint or conviction attached or by virtue of viewpoint was impossible. So the argument is that the European law basically allows courts to be obliges the court to protect equality rights from hateful and extremist speech, whereas the U.S. law basically allows court to prohibit certain hateful speech, but to a very minimum standard, only to stop imminent violence, as is pointed out in the landmark case of Brandenburg. So we know that these are the landmark rules, but what does it mean for the international or the global framework? It is actually it took a very long time for the international law to take shape. So if we take a look at the International Covenant on Civil and Political Rights, we see that these three blocks of rules are quite similar to what we saw just in the European Convention. So Article 19 is about free speech, and Article 26 is about equality rights, and it's also in a landmark case or communication of the United Nations Human Rights Committee. It is established that Article 20, which is about hate speech, should build up the bridge between free speech, Article 19, and equality rights. So this has basically shaped the conventional debate about the conflicts, potential conflicts between equality rights and free speech. But this kind of debate has continued into our current online hate speech scenario. So I argue that there are basically three layers of problems that can be attached to the regulation of online hate speech. The first one is technical. So basically there is a kind of decentralized filtering, that the kind of filtering or censorship power is decentralized to the media, to different platforms. And secondly, the AI, the artificial intelligence generated arithmetics has its own drawbacks, so that it's impossible for such kind of software or filtering measures to detect completely the online hate speech itself. And there are always indiscriminate risks attached to those words that could be understood as hate speech and those not. But there are also legal risks as well. So as we see, so just Jakob or Professor Robotham has used this kind of conceptualized this kind of soft and gray areas, and we see that in our daily in the daily practice of the government or public authorities, it's always very difficult for them to differentiate between those words or content or texts that could be stigmatized, or those that are simply neutral words, and the legislators are always slow to follow up, to catch up with the challenges and risks. And finally, there are so many difficulties in the judicial interpretation, and courts around the world always interpret different speech in different ways, and they have different laws. So that basically constitute the legal risks or challenges. And finally, there's the kind of political, I would call political problem or constitutional risks. So as we see that there is a kind of a bipolar constitutional mechanism. So Professor Matthias Hong also pointed out that the German constitutional law embraces the positive freedom, and constitutional rights are basically used to defend the individual rights against government interference. But this kind of bipolar constitutional mechanism has changed fundamentally, also in a digital environment, because of the media, the emergence, the advent of different media. So this kind of a media facilities has acquired new political power, and we call them the fourth power, the fourth constitutional power. And this has also changed what Montesquieu described as the three kind of separation powers, the three types of powers. So the law itself fails to respond to the challenges that the media has raised, to the regulation of online hate speech and the protection of equality rights. Now, of course, the other panelists have also discussed and debated about the most controversial law that we have today, which is Germany's Network Enforcement Act. So criticizers have branded it as a kind of digital Berlin Wall, but this is subject to further debates, of course. But what we know is that many countries, including the most developed or libertarian systems, have subscribed to this kind of regulatory model. So 2 years ago, France and New Zealand, together with many other big technology companies, have jointly pledged to fight against online hate speech. And now we see the proliferation of these enforcement acts and laws in the UK, in France, and in many other parts of the world. So on the other hand, the US still resisted this kind of a regulatory model. What we have seen in the famous New York Times case as the talismanic immunity. Again, in the US courts, we saw many times that, for instance, intellectual property rights have enjoyed this kind of talismanic immunity from First Amendment. However, in the most recent case, Mato, as we just mentioned, the US courts also reiterated that the laws prohibiting derogatory trademark names are viewpoint discriminatory, and they struck down this federal law. So basically, the question is whether or not the equality rights, right, or the intellectual property could enjoy talismanic immunity from other types of constitutional limitations, such as equality rights, as enshrined in the 14th Amendment. So it's a kind of heterogeneous contours, right, that we have today. And this global regime has called for a global cooperation. Of course, Chinese law and Chinese law on the regulation of free speech has generated tremendous impact on us. And we see from recent and from what we are still suffering from today, that this law from an authoritarian country is still generating impact. So China has actually subscribed to or echoed the global call for such online regulation of online hate speech. But on the other hand, it also pledged the protection of equality rights in its constitution. So if we take a look at the Chinese constitutional framework, we will see that apart from the Article 35, which prescribes free speech itself, I hope you received a document that I prepared in regard to the Chinese law. So Articles 4 of 33 and 36 to 48 all constitutional prescriptions about equality and non-discrimination. So, but this kind of balancing, or I would not call it balance, because the Chinese court will not be entitled to any constitutional review so far. But the national security or public order have imposed great restrictions on free speech itself, and also on equality or non-discrimination. So basically, around this authoritarian constitutional framework, the Chinese law has built up its own or unique model of regulating online hate speech. And I argue that there are basically also three layers. First is the political or censorship. We call it prior restraint, of course. But in that kind of model, all kinds of government authorities will be able to impose the censorship itself in the media. And the second layer is the legal one, the legal approach. or what the Chinese government prescribes as the rule of law or rule by law model. So we saw a variety of subsequent punishment. We saw that there is not only administrative penalty, but also criminal offense that could be well compared to what we see in the UK and in the EU. All of which are well advanced. And finally, what we saw as the notice and takedown regime has also been enshrined in the most recent civil code of the People's Republic of China. So we can call it a rights-based governance model, but it is as such established in conjunction with many other regulations. So for instance, the internet content provider, as well as the internet service provider, are not allowed will not allow those online hate speech, for instance, to emerge, and they have to install kind of filtering mechanisms. Otherwise, they will be punished, and the users themselves would also be punished as long as they receive this kind of a notice without appropriate response. So all the kind of rules and laws and regulations that we have just read from a European context have been taken over simply by Chinese law, but in a different way. And argue that this kind of approach particularly is established under the aegis of the protection of equality rights. And first, it is characterized by a kind of suppression of free speech or religious freedom itself. For instance, Articles 249 and 250 of the Chinese Criminal Code prescribes the punishment for incitement of racial hatred and racial discrimination. And we see in a bunch of cases, criminal cases in Uyghur, that those Uyghur citizens or netizens have been imprisoned and sentenced for publishing or spreading hate speech or hateful speech about the potential conflicts between the Han nationality and those ethnic minorities. This kind of racial discrimination cases are particularly important for Chinese courts, not just because of the rights-based approach, but because of the political context, of course. And that is integrated into the maintenance of political stability of the regime. And the second characteristic is the interest-driven administrative regulations versus equality itself. So there are many administrative regulations that we see that have been prescribed by different departments of the central government. And they usually allow or order the internet service providers to install a kind of opaque censorship process, which will result in kind of public opinions, which ties, for instance, most recently, sexual minorities with color or overseas color revolutions. And just last month, the WeChat shut down many accounts run by the LGBT and many NGOs for this reason. And finally, there's a kind of a demoralized pragmatism of media, as I call it. So it is rooted in, or the root of online hate speech itself is actually part of a broad and decades-long statist propaganda. And that kind of propaganda intermingled with state media and many fervent followers would keep changing the targets of online harassment. For instance, the Hong Kong pro-democracy protesters, or Wuhan writers, or New York Times journalists, or think tank workers, they have all been stigmatized under such a kind of propaganda waged by the government itself. But on the other hand, this kind of online hate speech has continued even today. If I don't know if this picture is a bit provocative to many, but it actually is quite prevalent terminology used in Chinese internet, referring to the white leftist who are usually those people who are educated but advocate for peace and equality in the eyes of many Chinese netizens, only to satisfy their own feeling of moral superiority. So these people would usually also care only about topics such as immigration, minorities, LGBT, and environment. But this kind of online hate speech or hateful speech used by many Chinese netizens were not punished, but instead used to stigmatize even those Chinese who endorse the Western or liberal democracy in a way. And in a case study, I would try to argue that this kind of ideology is actually rooted in the government's model or statist approach of demoralized pragmatism. Okay, so these are the basic elements that I will explore in my paper. Thank you.
And many thanks for that presentation. And then finally, we'll move on to Professor Kenyon and Dr. De Silva, whose presentation is entitled Hate Speech and Positive Freedom of Speech.
Many thanks, Oliver. Look, and thanks to the organisers for inviting Anjali and me to speak. We'll try and be quick. I think if our time runs out, we'll just stop. So there's a promise so we can get to questions and feedback. But I've really enjoyed hearing all of these talks, and I can see various connections with what we've been working on. I'm going to start with just a quick overview of what we're trying to get across, which we may not get through all of it. So, Anjali might say a little bit about terminology. We'd often use the term vilification more than hate speech, but you know the territory we are talking about. I'll do a brief introduction. We'll then move to some comments on the debate so far, or the debates so far that are often held about hate speech and its legal responses. Then say something about a positive free speech approach to how vilification might be treated by law. And then finally, vilification and what we call sustained plural public speech now, raising some questions about that, perhaps more than answers. So, hate speech and vilification. I mean, as we've seen in the papers already today, one area that people naturally talk about are restrictions. When might law restrict hate speech? On what basis? What exact speech? In what manner? Criminal, civil, etc. And equally, as Jake noted, people may talk about counter speech ideas. How might speech that would counter the effects of hate speech on the targets of hate speech be supported? Now, when thinking about free speech, the most common concerns are raised in relation to restrictions, arguments for or against restrictions on hate speech, and most often against, based on ideas of free speech. And the point we just want to add is there are free speech arguments that relate to counter speech, and particularly to the positive obligations that could be seen to flow from free speech, particularly in a democratic context, that might support calls to support the environment in which varied speech can happen. That will include counter speech, not necessarily just by government counter speech, but by both targets and others who'd want to speak on their in response to the hate speech. So it's really just trying to add free speech to both those elements, perhaps more than it always is. Now, I think that means I hand right now to Anjali to talk about the debate so far.
Thanks, Andrew. So I'll be quick with these points as well to leave some time for questions. But as Andrew has already said, free speech has traditionally been engaged with reference to its negative dimensions to argue against restrictive anti-vilification laws as illegitimate constraints on communication, particularly with reference to arguments from democracy as being illegitimate in liberal democracies. Such arguments can suggest that a counter-speech approach or counter-speech approaches to addressing vilification are prima facie more legitimate in and for liberal democratic jurisdictions. However, arguing against prohibitive anti-vilification laws or arguing instead for counter-speech approaches to addressing vilifying speech doesn't necessarily mean that without prohibitive laws, public speech is free, equal, or democratically sufficient. This is starkly highlighted in relation to counter-speech approaches to vilifying speech. Vilification may be conceived of as discriminatory treatment of target group members that constitutes and causes the subordination and silencing of target group members on the basis of their relevant ascriptive characteristics, so sex, race, sexuality, etc. And the reason that we use vilification interchangeably with hate speech is because it's not really the hate in hate speech that we're concerned about, but what that speech functions to do in the real world. It silences target group members by preventing them from engaging in speech acts, by marginalising and devaluing and debilitating their speech even where they can and do speak. It also makes it less likely that third-party speakers will be able to counter-speak on behalf of target group members. Those contextual factors suggest that what's required for effective counter-speech against vilification goes beyond an absence of speech-restrictive or viewpoint-restrictive anti-vilification laws. If what's required includes structural intervention, effective speaking back requires that free speech be thought of in positive and not just negative terms. And that's the central point that we're seeking to make. Free speech should not be drawn on only when assessing the legitimacy or otherwise of laws restricting vilification, especially their democratic legitimacy, but issues of free speech also arise when assessing the communicative environment in which speaking back can occur.
And that's back to me. So that moves us to the third part about a positive free speech approach to law and vilification. So thinking about free speech in positive terms has a whole host of implications. We've noted some by earlier speakers tonight. Often positive obligations are thought about in terms of the horizontal application of rights. The states having an obligation to allow non-state actors to protect rights against other non-state actors. But it also can entail access to information rights, rights of protest, so on and so forth. The concern we want to flag is what it can also mean in what we label sustained plural public speech. Right, and this particular quality of plural public speech that we think has democratic significance. Now, as has been noted already, I talk about this at length in a book that I'm just going to mention. Don't talk about hate speech at great length in that work, but talk about the general context and hate speech in passing. But we're trying to talk about, think about a context where society has a voice, formulates judgments, and makes effective claims of government. And that's what I've called a democracy of expression. And free speech within that has positive dimensions as well as negative. Now, I should note nothing in the analysis says, the only thing democracy needs is this sort of speech. If you get that right, everything will be fine. Nor that the only thing speech needs is law, but it would say in both instances, that's important. The law affecting the speech that you might have and the speech's influence on democracy. And the approach suggests that a central democratic role for free speech is supporting opinion formation, right, by individuals and groups. So as well as free speech supporting speakers, it supports recipients. And in many ways, the freedom is a freedom of reception in this quality. Now, the term we've used is sustained plural public speech. I'll try and say something very quickly about those elements. Public speech is probably the most straightforward. Right? You could use public debate, public deliberation, etc. It's varied speech in our approach, not only sort of philosophical debate that academics might engage in. And it's public in the sense of forming publics. You send speech out there, it finds an audience, they continue the speech, you create a public through that process. And that formative role is a reason for seeking diversity in public speech, because any public formed by speech. It excludes as well as includes. When any public is taken to be the public, those limitations will order the political world. And that would bring us to the second point, the term plural in sustained public, plural public speech. And pluralism here is probably what you're thinking of when I say pluralism or diversity, but it's sort of that squared. It's an extreme version of that you would never reach. But here's a long quote about it. I'll simplify it in a sec. But you can see something where you would have a structurally mixed media environment with multiple and varied institutional forms, varied organisations, varied staffing, management, participants, economic support, and so on. It is in short, an environment with diverse media entities, diverse funding, diverse missions, and diverse people both involved in their operations, in their content, and as their audiences. And of course, you can only achieve that sort of plurality in part, but you can imagine degrees where it is closer to it or further from it. And that partial quality is not surprising when you're talking about the positive dimensions of free speech or many human rights in general. And the claim we'd make is that it's not plausible to imagine that substantial plurality happening without state action in its support. The last term that I mentioned was sustained. Sustained's probably the one that's hardest to apply in the contemporary communications environment. And it's also, though, what has often been assumed in historical analyses of free speech. There will be this environment that sustains public debate. In large part, historically, that was through journalism and different forms of media, drama, etc., right? And it was also sustained through what can be called the civic disposition of audiences to use speech informing democratic opinions. We just note both those aspects are changing and perhaps changing very substantially. I'll throw back to Angela.
I think we maybe have about a minute left. So very quickly, once it's accepted that freedom of speech has positive dimensions, it's relatively easy to see that systemic silencing through vilification is relevant to law. And a positive conception of freedom of speech assists in framing the forms that vilification regulation might take. The first point is that anti-vilification laws may be conceived of pursuant to a positive free speech approach, not as a complete response, not even as a primary response perhaps, to problems of vilifying speech, but as part of the overall conditions necessary to enable effective counter-speech against vilification and in favour of democratic opinion formation. As positive free speech is presupposed by democratic forms of government and by law, regulation for sustained plural public speech may also be conceived of as part of those overall conditions. The second point is that it's not that anti-vilification laws would necessarily never be needed, but that their degree and form would differ where there was more and more effective counter-speech. So where something like sustained plural public speech is present, not all manifestations of vilification would harm, presumably in the relevant ways, and prohibitive regulation of vilifying speech through relatively narrower anti-vilification laws might be better justified. Overall, regulation for sustained plural public speech would include laws and judicial interpretations of existing free speech guarantees directed at a structural diversity of speech of the kind that Andrew has just referred to. It would be institutional and institutionalised capabilities building through law with the aims and functions, as the slide says, of enabling target group members to speak back, enabling other actors to speak back on behalf of target group members, and enabling the reformation of publics of target group members impacted on by, in particular, the silencing harms of vilification. And I'll throw back to Andrew.
Now, and given the time, I might stop in just a second. What we were going to say about now is really that many people would say there's more speech now. And yeah, that's true in a way. We'd say, but there's not necessarily more of what we call sustained plural public speech. It's actually thinking about the role of that in a democracy means that it's challenging to work out what to do about vilification in this environment. And the points we were just going to note about that are the increasing commercial domination of the distribution of public speech, the changes to journalism, both in terms of resources, its connections to localities, and its historic gatekeeping role, which has removed some, and with the emphasis on some, vilification from wide public circulation, which doesn't happen now. And also the habits of reception, the audience disposition I mentioned before, towards democratic opinion formation. All of those things are changing. And where you end up with is an idea that, well, some responses that support sustained plural public speech will be helpful in this environment. They, in fact, may be needed more than they were historically, but that still will leave a place for restrictions. And in fact, the challenges of supporting sustained plural public speech in this environment might mean you come back to restrictions being even as important as they often are thought to be. Right? It's just adding that context. That isn't the whole story. Anyway, at that point, I shall stop.
Many thanks for that excellent presentation. Now we've got 15 minutes or so where I can take Q&As from the audience. At the bottom of your screens, you'll see there's a Q&A function. And once we've worked through those, I've got a few questions of my own to continue the discussion. So we've got one from all to all the speakers, and it asks, how is the discussion influenced here, given the increasing knowledge of bias in AI? So I suppose considering the ways in which various platforms filter or moderate or curate through those technologies. And how should that awareness affect current policy discussions? Would any of the speakers like to address the role of AI and bias within their topics?
I can have a go at answering this, Oliver. It's not directly relevant to Andrew and my paper, I don't think, and positive free speech and its interactions with hate speech. But what I will say really briefly is that this is an emerging area of scholarship and of policy, and what is emerging is what you would expect to emerge, which is that AI that is trained by individuals and organisations with biases around race, sex, gender, sexuality, etc., as the question asker has identified, are also influenced by those same biases. And what's apparent is that there's both over and under inclusiveness in terms of the hate speech being captured. So there's under inclusiveness typically around speech that is hate speech but is not being recognised as such. This is particularly relevant in relation to hate speech against women, for example, which is fairly normalised in ways that make it even more invisible, perhaps, and pervasive than other forms of hate speech. Recently, Facebook published for public comments a case they're looking at in which the phrase, well, a particular word was censored or identified as being homophobic, but the same post contained words that were clearly misogynistic as well, which were not identified as hate speech, even though on the face of it, their hate speech community standard covers that kind of misogynistic speech as well. So you see under inclusiveness there, particularly in relation to particular categories of speech, but you also see over inclusiveness where target group members, for example, are being censored for co-opting language that might be harmful if used by other groups, but is kind of in-group language when used by target group members themselves. And AI is just not able to pick up those nuances at the moment.
Oliver, sorry, if I could just jump in as well, just to pick up on what Anjali said, which I agree with entirely. I think one of the things I touch on in my paper is this kind of issue that where you've got AI being used to try to work out what is illegal content, to what may be hate speech or what may be legal yet harmful content. You run the risk, as I said, of legitimate content that isn't actually illegal, or content that perhaps isn't actually manifestly harmful, being censored as a way to kind of protect the platforms from any liability. So they kind of take an overcautious approach to monitoring the content just really, to ensure they're covering all their bases and that they're not going to be subject to potentially huge fines, which under the online safety bill, if they do breach their duty of care, they potentially could be. The ramifications for them financially could be huge. So there is this concern that they over censor, just really as a kind of a way of protecting themselves. But that was all I was going to say, and I think it just kind of builds on what Angelique said. So yeah, thank you.
If I may, I would also agree with what Peter Cole just said and what Angelita Silva just said. And I think the artificial intelligence and their discriminatory effects have to be taken into account when understanding free speech as a positive freedom and the obligations that governments have to provide a framework for sustained public plural speech, as Andrew Kenyon has put it, should take that into account, I think. And maybe I can just add a short word about Jacob Robertson's excellent presentation. My commitment to viewpoint discrimination prohibitions ends indeed with those soft controls. I think funding or counter speech and fostering counter speech by government can discriminate according to viewpoints, at least if those viewpoints are those protected by the Constitution and the fundamental rights. So if the government defends the Constitution and defends the value of non-discrimination, for example, against hate speech by producing counter speech, fostering counter speech, funding public broadcasting, etc., I think the prohibition on viewpoint discrimination should not apply. Thanks.
Oliver, can I just make just an additional comment? My experience of what's coming out in the literature on this, on the use of AI, is not just to clarify that there's over-inclusiveness in what's being captured. I think what's coming out is that there's inconsistency in what's being captured. There's still a vast amount of hate speech that's slipping through the gaps, that's not being captured at all. But what's really concerning is that we've essentially given over an administrative function, and there's no consistency or transparency and accountability in relation to those decisions. So it's more the concern is around inconsistency rather than over-capturing at the moment, I think.
I suppose if I could ask a follow-up related to that then, what would be the role, in the panelist's view, on the role of the positive state in regulating the design and use of such technologies? So it's a good example of something that the European Union's now exploring. Does that fit within these frameworks, I suppose, of the positive obligations of states to shape the online space?
Perhaps as a very quick observation, I think maybe it would be fair to say theoretically in Europe it might, but I don't think they've ever gone that far. So there's implications of how they analyse the positive obligations that flow, say, from the European Convention as well as then the European Union itself. But they've left a lot of room there. And so I think the strongest due protection you see are in more particular national jurisdictions. The strongest model, I should say, of this understanding of positive dimensions of particularly free speech. So Germany and France as well. So Germany more in practice, France perhaps in theory.
Thank you. So we've got another question in our thread from Rachel Tam, asking all members of the panel, what's your view on imposing duties of care on social media platforms to combat hate speech? Should such duties be imposed on social media platforms?
Perhaps if I just jump in and answer that one. I think, I mean, it's certainly in my paper, I talk about, as I did in the presentation, some of the concerns around imposing these duties of care. And I think part of the problem with the online safety bill at the moment, and this is something I didn't mention in the presentation, but I talk about in the paper, is actually the vagueness of the bill at the moment. It's a complex piece of legislation. As I said at the start, I've kind of opened Pandora's box for myself in trying to deal with it. But it's very vague. A lot of the legal detail isn't actually drafted yet. It's not included in the bill as it currently stands. It's going to be subject to secondary legislation once the bill is enacted. So it's still very much a guessing game as to what the final piece of legislation is going to look like and what that impact on free speech will actually be, or what its impact could be. But imposing those duties of care as they stand, and because of their vagueness, certainly in terms of the way they've been defined, creates a number of those kind of concerns that I highlighted in the presentation. And I should add that the concerns I highlighted in the presentation are the highlights. There are many, many more, and indeed, even if you look at the House of Lords, the Digital and Communications Committee recently published their free-for-all report, which was scathing in its kind of view on the online safety bill and its duties of care and what that may mean, or what they may mean, I should say, for free speech in the UK.
I would agree there as well, and I would consider this as part of my third point. I think I would try to share the paper with everybody. Just 3 points, and the third was that there have to be fairness obligations on social media networks, and I think duties of care would be an example to protect the rights of personality of victims of hate speech, for example. Thanks.
Yeah, I think it's not clear to me at all that tortious duties in the forms of duties of care, for example, are the right way to go. And I agree with both Peter and Matthias that there are, grave concerns again around administrative inconsistency. But I think if we're to take the harms of hate speech seriously, as they relate to target group members in particular, but also as they relate to audience interests in hearing and having access to a good speech environment, it's very clear that any legal response needs to involve a platformed response. This is not something that governments can deal with without the cooperation of platforms. The vast majority of hate speech is now found online. And, regardless of what the solution is, it needs to include platforms. I don't have the solution though.
Just going to jump in there. Actually, I would entirely agree with what Angela said. It has to include the platforms because the other methods just simply haven't worked. Trying to deal with it from as I said in my presentation, from a kind of a publisher perspective, there are just simply too many of them. The current system we have, the liability system we have, can't cope with dealing with the publishers. It has to be dealt with at a platform level in some way or other, and they need to take some responsibility for that. The problem we've had, of course, in the past is that self-regulation hasn't really worked particularly well. It's been applied inconsistently. We've seen the platforms sign up to various regulatory initiatives to varying degrees of success. And I think in the UK, a really good example that highlights all of this, and this is an example that I talk about in the paper, is what happened after the final of the Euro 2020 in the UK, where we had England played Italy in the final. And after that final, 3 of those England players were subjected to a lot of abuse on, in particular, Twitter, a lot of racist abuse on Twitter. It turns out Twitter then permanently banned about 30 of those individuals that were directing that abuse at those 3 particular England players that missed the penalties in the final. And then a couple of days later, it was found that those 30 individuals were actually on Twitter again, using the platform just using a slightly different name. And Ofcom then have come out and since said, this just simply isn't working. What the platforms are doing at the minute just isn't effective. And this is a kind of a case in point to highlight why it isn't effective. So I completely agree with Angela that, something more needs to be done. I just don't, unfortunately, have all the answers.
If I could quickly just add my comment, because I think the question is largely a European one, because in the US you have the First Amendment, and in China you have the full-fledged censorship. So China has already imposed the obligation on social media, not only the social media, but also all content providers, all content producers, and the users everywhere. So there's obligation everywhere. But one good thing or an experience that the Europe might profit from this situation is that Europe is largely still in the phase of discussing the question whether it should. So it could learn from the US and from China. So you could see the negative consequences of what a censorship would be like in China, and also what it would be like in the US if the US government never imposes any obligation on Facebook and Twitter. But I agree with the other grave concerns, and the constitutional framework in Europe should be the basis for the discussion.
Many thanks for those comments in response to questions. I'll just check our questions. There are 3 more, but I don't know whether we have time to cover them all, so I might just pick out particular parts. Okay, so perhaps the question I could focus on then as a final one for the panelists is, how far does the global spread of online hate speech regulatory initiatives carry a risk of creating diverging consequences between democratic and undemocratic countries? So to what extent could the application of that model globally have divergent effects?
Just maybe if I could just start on that. I think that's a really good question, actually, and I don't really have a particularly good answer, I don't think, but I've got a few thoughts on it. We're seeing, obviously, at the moment in lots of different jurisdictions, we're seeing, you know, new regimes been developed to deal with hate speech. So this isn't just a problem that's a UK problem, it's a worldwide problem. We're seeing obviously the online safety bill in the UK, we've seen NetzDG in Germany. Canada have now said that they're going to develop a similar regime to deal with hate speech, and we've seen other jurisdictions doing it as well. And I agree, the problem is how do we get that kind of, is it possible to get some sort of uniformity? And I would say probably not. I think it's going to be very difficult to get uniformity across jurisdictions because, of course, you've got cultural issues. You know, what's acceptable in one country may be completely unacceptable in another jurisdiction. And particularly when you've got very vague kind of terminology as we have in the UK, you know, we haven't even really defined what hate speech is in the UK. When it comes to the online safety bill, we haven't really defined what legal yet harmful speech is. That's not defined properly. So I think at the moment it's going to be really difficult to kind of get that uniformity, which of course is then going to potentially lead to inconsistencies in how the platforms that are of course multi-jurisdictional, they operate around the world, how they are then going to deal with content within their different jurisdictions. You know, are they going to have one algorithm that works across the world, or are they going to have different algorithms, for instance, for each country that they're operating in? I don't know, but it's certainly going to be a challenge.
I just want to send this article to you all. I just used it, so I think it addresses this question partly.
I'm also not that sure how far uniformity is desirable in any event, because you might say each state should strike their own balance along the lines that Peter was saying. I also think it can be something worrying if you've got a single authority that is going to, or you have a uniform approach with there's a single authority making these decisions about what's permissible or not. So I think some kind of diversity among different nations is probably desirable as well.
Okay, so I had a message that we can carry over time to look at final questions as well. They both have a similar theme in relation to vagueness. So when we're talking about regulation in this area, especially in regards to private media platforms, is it arguably too vague? And the other question refers to the problems of vagueness in the background legal frameworks. So is that trend of vagueness then a bigger threat? That's at least beyond the US.
I might just say a little on that, which is I think it raises, and maybe particularly the second question there raises a really interesting issue we didn't really address in our panel as much as we did address, which is what you might call the effectiveness of different methods of hate speech regulation, whether they're online or offline. That is, what speech ends up being caught by them, whether it's in criminal or civil approaches, and the challenges of creating a model that will have the effects that might be desired by, let's say, Parliament when it's passing that. And I think that is a real challenge. I don't have a particularly good answer to it. I know in the Australian context, and in fact, Clive Walker probably knows as much as I do on that or more, but there's a lot of examples of sort of low-level police offences being used against public hate speech and being used in what appear to be quite discriminatory ways, so as into who gets caught up in these provisions. And that's a challenge that's existed for a long time.
I think also issues of vagueness are probably more pressing when we're looking at, say, criminal law sanctions, because if you're going to impose a criminal penalty against someone, you need to give them stronger advance notice about what's prohibited. Whereas when you're dealing with regulation, arguably the whole advantage of regulation is that there's greater flexibility that can be tolerated. It also depends on who's suffering the disadvantage as a result of the vagueness. So if it's a social media company, maybe we're more willing to tolerate a degree of vagueness in the instructions that's given to them, as opposed to the instructions that are given to individual citizens. So I think regulation can be problematic in the vagueness of some of the provisions, but it raises slightly different issues from that of criminal liability.
Professor Hoffman, you've got your hand up.
Yeah, I think the laws against hate speech, at least in French law, are not really vague. Of course, there are always hard cases, difficult cases, but there's also a decades-long case law, and in the majority of cases, it's not that hard to know whether an expression falls or does not fall under those provisions. A different question is whether the moderators, or even less the algorithms from Twitter or from Facebook, have the ability to apply those laws. So it raises the questions of the formation they get, the information they get, and in the French recent law, there is this provision that says that they must put in place some formations for their people. They must have sufficient peoples, but those peoples must learn how to interpret the French law against hate speech.
Yeah, if I could add to that, I mean, there is a vagueness about, hate speech standards. There is possibly even more vagueness when you say platforms have to take down things that are legal but harmful, because then you open up a huge additional discretion. But then a separate form of vagueness is how platforms actually exercise their discretion. And I think there needs to be, in addition to training of the moderators, there needs to be also transparency in terms of the criteria they apply to make these decisions, whether something is or is not harmful, or is or is not hate speech, and so on. So.
Okay, so I think if everyone's happy, I'll sum up and close the seminar. So it's been a fantastic seminar this morning. Thank you to all of the panelists and for everyone who's helped to organise it as well. this morning. I thought it was really striking that the debates this morning move so far beyond talking about prohibition and criminalisation to really look at a whole range of different tools, from curation and moderation, speech and counter speech, funding and platforming, both by private and public actors, and the ways in which they can all contribute to that positive promotion of a diverse set of entities, funding, mission, and people. I thought it was a particularly striking phrase. So thank you to all the panelists. I'll hand over now to Sophie to close the session.
Thank you, Oliver. So my role is to truly bring this webinar to a close, and I want to thank warmly our chair. I want to thank, as Oliver did, our panel for your fascinating contribution, for each of you giving us a very clear picture and very clear lines of arguments to feed into a rather complex debate. BAC will act as a point of contact for lawyers in different countries. Please do be in touch if you wish to collaborate and are interested in writing for publication on our website. But for now, thank you very, very much. And I hope that you will join us again when we host another seminar online. So thank you very much indeed, and have a good day or a good evening. Thank you. Bye.
Bye, thank you.
Bye-bye.
Thank you, bye.